Hello, and welcome to NWA Vet Presents. Today we are looking at a certain portion of the PACT Act, that is, the Camp Lejeune Justice Act. We will start with a very brief overview of the issue with Camp Lejeune and Marine Corps Air Station New River. We will look at the illnesses which are already presumptive for veterans who were stationed at Camp Lejeune. We will look at the illnesses and conditions for which veterans and family members can receive health care reimbursement and the requirements for that. And finally, we will look at the new Camp Lejeune Justice Act and see what it all means. First of all, what happened at Camp Lejeune? In 1987, it was discovered that two of the drinking water systems supplying drinking water to base housing areas on Camp Lejeune were contaminated. The main contaminants of concern were trichloroethylene and perchloroethylene, but in addition there were dozens of other chemicals present in the drinking water contributing to the contamination. The VA has established 8 presumptive illnesses which they presume to have been caused by exposure to the water at Camp Lejeune. These are the 8 illnesses for which the VA will pay disability compensation. They are adult leukemia, aplastic anemia and other myelodysplastic syndromes, bladder cancer, kidney cancer, liver cancer, multiple myeloma, non-Hodgkin's lymphoma, and Parkinson's disease. Now again, I repeat, these are the illnesses which the VA has established presumptive service connection for and will go ahead and pay disability compensation. In order for a veteran to file for VA disability compensation, they must have military records which show service for at least 30 cumulative days in the correct dates at Camp Lejeune or MCAS, and that would be from August 1953 through December 1987, anywhere in that time period. In addition, they must have medical records stating they are diagnosed with one of those 8 illnesses. Now, these are the only 8 illnesses which are presumptive for compensation. As for health care, totally different from compensation, but as for health care, veterans and family members are eligible for health care benefits, and the VA may pay them back for out-of-pocket health care costs related to any of these listed 15 conditions. And you see the 15 listed conditions here. Now again, I tell you that this is for health care benefits and possible reimbursement for out-of-pocket health care costs. As for family members, in order to receive these benefits, the family member must provide the following requirements to the VA. First, as a family member, they must prove a relationship to the veteran who served at Camp Lejeune or MCAS New River. In addition, there must be some type of documentation which proves that they lived at Camp Lejeune or MCAS New River for at least 30 cumulative days within those same time periods. Examples of paperwork could be utility bills, base housing records, military orders, tax forms, etc. But there must be something in writing showing that they lived at Camp Lejeune or MCAS New River for at least 30 days cumulative within these 2 time periods. Then the family member must also provide medical records showing they were diagnosed with one of those 15 conditions, as well as the date the illness was diagnosed, and that they have been treated or are being treated for the illness. They must also furnish proof that they have paid for those health care expenses. Remember, this is reimbursement for out-of-pocket health care costs, so they must furnish proof that they have paid for those health care expenses. Now, the VA form to apply as a family member for Camp Lejeune is the Family Member Program Application, VA Form 10-168. I've included a link in the video description below to that form. So, that explains how the VA has historically handled Camp Lejeune claims. Now, the Camp Lejeune Justice Act, which was signed into law on August 10th of this year, makes it possible for veterans and family members to seek action if they feel that the VA has not acted correctly regarding their conditions which they believe are related to the Camp Lejeune water. The Act makes it possible for individuals to bring action against the federal government. It also sets the burden of proof, sets the jurisdiction of the court action, and sets the terms of the remedy. Now understand, this refers to bringing action which the veteran or individual feels has not already been addressed. If the illness has been addressed by VA compensation or by the Camp Lejeune Family Member Program, then there's no need for filing action. If it's something like the 8 presumptive illnesses or the 15 illnesses on the other slide, then veterans and family members can seek action that way. This opening up for court action is only for individuals who feel that their needs have not been adequately met. Therefore, there are certain extra requirements for bringing action against the United States government. Okay, according to the Camp Lejeune Justice Act, an individual, including a veteran, who was exposed to water at Camp Lejeune for at least 30 days between August 1st, 1953 and December 31st, 1987, to water which was supplied by or for the United States, may bring action in the U.S. District Court for the Eastern District of North Carolina to obtain appropriate relief from harm caused by exposure to the water. The burden of proof is on the party filing the action. This means that the person or their representative who files the action in the court must provide evidence of the relationship between the water at Camp Lejeune and the harm or the illnesses that they are claiming. The proof must be sufficient to show that the water did cause the problem, or that it is at least as likely as not that the water caused the problem. And remember, just like any other evidence in the case of health matters, this proof will most likely need to be medical evidence of a causal relationship. So it's going to be on the individual who's filing the claim to show proof that there is a reason for the claim. And there are certain terms which will apply to any award approved by the court in these cases. First, anyone who brings an action under this law cannot bring a tort action against the U.S. for the same illness under any other laws. Second, if the court awards a monetary amount to an individual, that amount will be offset by any other amount that's already been paid for the same health care of that disability by either the VA, Medicare, or Medicaid. In other words, if you've already received compensation or help with that bill from the VA, Medicare, or Medicaid, you're not going to get paid for that portion of it. The reimbursement is for out-of-pocket costs only. There will be no punitive damages awarded. I know everyone has heard of the millions of dollars that are often awarded for pain and suffering in some court cases. According to the law, that will not be the case here. The law itself states there will be no punitive damages. This is for reimbursement of out-of-pocket medical care costs. Before an individual can file the action with the court, though, they must comply with the U.S. Federal Code, which states they have to file a claim with the federal agency first. In other words, veterans must file a claim with the VA. Civilians must file a claim with the VA using VA Form 10-168 that we talked about earlier to give the VA a chance to respond to the claim. Only if they receive a denial from the VA are they then eligible to turn around and actually file a claim with the court. There is a time limit. Veterans and family members have until August 2024 to file the claim. And I'm sure you've seen and heard radio and TV ads, as well as ads on the internet, telling you to join a class action lawsuit for Camp Lejeune water compensation. You need to understand that these large law firms are hoping to get thousands of veterans and family members signed up, because the more people they get, the more money they're going to get. Remember, they're going to get a certain percentage of any money awarded. So for one person, that may not be very much. But the more people they sign up to the lawsuit, the more money the law firm is going to make. They don't really care how much you get. As long as they have enough people on the lawsuit, then they're going to get a big payout. Don't get sucked into the class action promises. Take your time. Decide what is best for you, and then take the action that you think you should take. Do you have any questions about this? I know this was a very quick look at Camp Lejeune. There's a lot to it, a lot of possibilities. If you have questions, you can contact your local Veteran Service Officer. They cannot recommend a lawyer to help you, but they can give you advice on how to file the proper paperwork with the VA for either veteran or civilian, and they may be able to give you some advice about what to do going forward. We hope this presentation has answered some of your questions. As always, feel free to email us with any comments or questions at info@nwavet.org. You can find us online at www.nwavet.org.